All right, everybody. It is now 1 o'clock, so let's go ahead and get this Wednesday webinar started. I am Nick Stout, the Idaho Realtors Communications Director, and I'd like to thank you all for joining us here today. This is a fun webinar we do throughout the year, usually once or twice a year, where we invite our wonderful legal counsel, Jason Risch, on and have him talk to us about some of the recent form changes. So new form changes went into effect here in the last month, and we are excited to maybe see what Jason has to say about those. So Jason, without further ado, I'm going to turn the floor over to you. Everyone, thank you for joining us for our webinar. One last reminder, please keep your microphones muted during the call today. Just helps us keep disruptions to a minimum. If you have questions, throw them in the chat, and we'll get going. But Jason, thank you for joining us, and the floor is yours.
Thank you, Nick. Welcome, everybody. Hopefully we can have a good discussion here today regarding the forms. As Nick said, the new forms were published about a month ago, but you've got something incredibly timely here happening today that we'll get into in just a minute. But before I start, it's appropriate that we acknowledge those that are on the IR Forms Committee and the hard work that they do to update these forms, to keep them timely and to make sure that issues that are coming up with the forms get addressed, and just continually working to make those forms better. And for those of you who don't know the process and don't know sort of how this works, the president appoints a committee like all the IR committees, that is the Forms Committee. That committee's job is to receive all comments from you or from me as legal counsel or from whatever the source may be about the forms. And they take it very seriously. And every suggestion that you as a member have, you can submit those forms suggestions to IR. IR catalogs all of those through Melissa Gray's hard work. She keeps track of all those throughout the year, and then she assigns those to form members. And so while there may be multiple comments about, hey, we should move a signature block here or there, sometimes there's unique comments, but she gathers them all up and puts them into kind of categories, and then they actually get assigned to an individual form member. That member then reaches out if it's not obvious from the question, if it's not like some typo or a typographical correction or formatting, then the committee member will reach out and they'll discuss it with you. They'll say, what was the problem that you ran into with this form, and how could what's your suggestion for fixing it? And they really take some time ahead of the Forms Committee to do that. That Forms Committee member then brings it to the Forms Committee, and they, as they like to say, they cuss and discuss all the possible changes, and they actually do spend time doing that. And at the end of the day, the change may not be accepted. It's a majority rules vote, but it is put in front of the committee. And so, like I said, they take this all very seriously. They do a lot of hard work to keep these forms in the excellent condition that they're in. And as you know, here in Idaho, virtually everybody throughout the entire state uses these forms. They are available to all members, and that's statewide. That is something you enjoyed. It's unique to Idaho Realtors. I can tell you, in talking with lawyers from all across the country, that is not something that all realtor associations enjoy. In fact, there are, if you know folks from other parts of the country, when you're doing your networking, I'm sure you hear them tell stories. And some folks have to have five or six forms, depending on where they're operating, and they have to know what those forms are and all little parts of those forms to serve their clients and customers. So for you guys to have a statewide set of forms it's really a great benefit to you. Now, having said that, that Forms Committee actually is also a benefit to you. They are represented from all over the state. So there's somebody from North Idaho, there's somebody from Eastern Idaho, from Treasure Valley, Magic Valley. There's big brokerages, small brokerages. There's farm and ranch, residential, commercial. It really is a great sort of cross-section of practitioners, and so that the suggestions that are made may be good for one particular part of the state or one particular maybe real estate, like residential real estate, but it might not work for farm and ranch. And so they will talk about that in the committee and decide. It all goes into deciding whether they're going to adopt these changes. So with all that, anytime you see anybody that's on the Forms Committee, they deserve a big pat on the back and a thank you for all the hard work that they do. They meet throughout the year, but they'll take about 2-3 days out of their lives and come to Boise to have those meetings. And then they do have remote meetings throughout the year. So it's really great work that they do on the Forms Committee. Speaking of meeting remotely, but it's one of the things that the Forms Committee can do now is to act quickly when there is a change that is needed on the forms. That is, as I said at the beginning of this, you guys are all perfect on timing because the forms just changed this morning. You may not have noticed it, and it wasn't a tremendous change, and it wasn't something that was broadcast too far and wide, but it deals with the FinCEN report. And I'm kind of smirking because there's other development that happened just this week, but I'm going to share my screen now and show you, as of this morning, the forms are now reflecting this language that you should see on your screen there. Nick, can you see it? Are we good? Hopefully. Okay.
Yep, we are good.
Okay, I wanted to make sure that everybody could see it. So you can see right there, it's section 45 is now as part of your forms. And what it is it's just a disclosure. It's not much different than the lead paint language type of a disclaimer. It's not asking for the information for FinCEN. It's not telling somebody they have to do this or making it the contingent of your purchase sale agreement. But it is disclosing the FinCEN law that existed up until recently. So that is the other timely part of this forms webinar. We had Forms Committee met.
Northern Trust Asset Management Chief Investment.
Got somebody who has a hot mic there. Anyway, so the Forms Committee had met. They discussed, okay, we all knew FinCEN was coming, and we knew what reporting obligations are. If you're new to this, I'll go over it in just a minute. But this FinCEN started March 1st, and so the Forms Committee wanted to make sure that there was some language in the forms. They went back and forth with different options as to how realtors were going to address this FinCEN language. And ultimately, this was the disclaimer that was decided upon, voted upon, and added to your forms. And it was, again, just to notify your clients and customers in a purchase sale agreement that they might have this reporting obligation if the transaction falls under this umbrella. But as I said, as ever moving, legal situation as the law is, whenever there's something new, it's always something that can get challenged, and that's what happened to the FinCEN. Just this week, there was a decision handed down from the Eastern District Court of Texas, where a title company sued the federal government to say, you don't have the right to make us fill out these forms or frankly, to make people report this information. And so eventually the punchline here is the judge agreed with them and the judge struck down the FinCEN rule. So as we sit here today, that FinCEN rule has been suspended, and whether or not they appeal this, whether or not the federal government regroups and does this a different direction, the smart money is that they're either going to appeal this or they're going to come at it from a different direction. And let me explain to you why the court struck it down, so you can understand how they may go about fixing this with the statute. But the rule was created by the administration, and so basically by an agency. The agency has the power to enact rules. That power comes to them from the statutes. And so the FinCEN document basically investigating transactions, that was all part of the Patriot Act. It was part of the 9/11. It was looking for money laundering, terrorist organizations, drug organizations that may be getting involved in transactions. How can the government see those and spot those earlier? And that's what this was all about was, if you had a transaction, reportable transaction under FinCEN, which a reportable transaction, for those who, if you weren't tracking this, it was an all cash deal. It was not financed. That was number one. Number two was it had to be for real property. And number three was that the buyer had to be an entity, whether it be a trust or a corporation or what have you. And so when those three things were triggered, then the federal government, through the FinCEN rules, said, you've got to tell us certain information when that type of a transaction happens. You have to report that to the government. So that was the rule. The problem was, and the challenge in the court was that the statute simply says that the government can impose obligations on the citizens to report suspicious activity. And the word suspicious is what was used in the law that came from Congress. And that's where FinCEN came from, was they said, oh, well, this could be a suspicious transaction because it's all cash and meets these other requirements. Bit of a stretch, probably, to say that for every one of those types of transactions. Yes, those transactions could be suspicious, and when there was suspicious activity, it typically looked like that, non-financed and through an entity. But what the reason the court struck down the rule was no, that's not good enough. When the law says you can force people to report suspicious activity, you got to at least have suspicious activity. So, in other words, just because somebody bought a residential home with an entity with all cash, that's not necessarily suspicious. As we know, that happens from law-abiding citizens every day. So that's where the court struck it down and said, no, you've gone too far. An easy way to correct it will be through statute, and so we expect that the federal government will continue to look at this as a way to battle terrorism and drug dealing in America. But as we sit right now, it's off again. So FinCEN has had a on again, off again, spotty regulatory issues over the last few years. They've suffered some blows to some things they've tried to do, and it's frustrating, I know. But as we sit right now, that's the latest news on it. Stay tuned. As I said, there could be appeals and things happening. But the forms committee, when they learned about all of this, and as I said, they were trying to put some language in your forms to help out your clients and customers. This will stay in your forms. It's a disclosure. There's no reason to pull it out of here. It just it says, hey, be aware of this, that you might have to fill out these reports. By the way, before the court struck this down, all the buzz was about who does these reports. What do they look like? How's this going to work? And of course, over the last 25 days, that's really worked itself out. But it was never, ever a realtor's obligation or a real estate licensee's obligation to report this. It always fell to somebody in the reporting cascade, which was a title company, maybe a lawyer if they were preparing a deed and there was no title company. There was kind of this cascade of people who had to report. Never did a realtor end up in that cascade. And in fact, at the very end of the cascade, it says, by the way, if there's none of the above, then don't worry about it. Nobody has to report it. So it had never fallen to us, to you as realtors. Now, obviously, you work closely with title companies, you work closely with the buyers and the sellers. So it comes into your sphere, but it's not something you're necessarily responsible for taking care of. And that's why there was no form from IR that had all that information in it. The obligation fell to title companies.
Hey, Jason.
Yes,
Jason, John McLaren here. Just for clarity and simplification, one, thanks the Forms Committee for identifying that, because really this is a disclosure that title would be responsible for following up on. How it relates to us directly is it could screw up a closing date if your client did not pay attention to it.
Yes, exactly. And that's why the Forms Committee wanted to put something in here. And what's interesting about that is actually the FinCEN report isn't due at closing. It's due up to 30 days after closing. So that was kind of a wrestle a lot of people had was, well, wait a minute. We can't even really make the purchase sale agreement contingent on doing this report because this report could be done later. And but yeah, I understand what you're saying. It could definitely title companies. I'm sure we're telling everybody, look, we need this information before you get to closing, and it could really mess it up. So this was something to be able to go back and say, look, buyer, look, seller, we told you this possibility could happen. So that was what the Forms Committee wants to do with that. But thanks, that was good comment, good input. Okay, let's move on. So that's FinCEN. Any other questions about that before we move off of FinCEN? All right. And Nick, I'm relying on you to monitor chat. I don't have it on my screen. So if there's anything that comes up, feel free to jump in. So let's talk about something else that there's been a lot of discussion about on the new forms, and that deals with the title inspection section. Let me bring it up here on our screen so we can all see what it is that we're talking about. So we get to, sorry. Okay, so we're going to get to section 11, and this has two parts to it, and I want to spend some time talking about both of the different parts. When I say parts, meaning updates. So there were two updates to this year. The highlighted language on your screen you will see is what was added. And so the first part of this I want to talk about, this relates to the buyer and the buyer's right. And so the way that this used to read before was that, as we all know, the buyer was provided with a copy of a title commitment as well as CC&Rs. And forget about the CC&Rs for now. This doesn't touch on that. It talks about the title commitment. So a buyer would get the title commitment, take a look at it, and they had an opportunity to object to the condition of the title. perhaps a lien had shown up or something that they didn't like on title. It said, look, when I entered into a purchase sale agreement, I was going to buy this property thinking that it was free and clear title, and that it had marketable title. And there's something on here that's not. And so I'm the buyer. I look at that and say, no, 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 I don't want any part of this mess. I'm terminating, and that I'm not, because I'm not buying what I thought I was buying. And that's only fair that a buyer should have an opportunity to look at the title. As we all know, there's a lot of things that can come up. And so the buyer needs to be aware of what they're buying. The language that's there in this first paragraph, lays all of that out and says the buyer shall have 2 days to object in writing. Then once a buyer objects, then that actually comes into this third paragraph down here. This all used to be part of one paragraph, but it's now divided up a little bit. So in this third paragraph, it says if the buyer does not timely object, this is what happens. And if they do object, this is what happens. Give seller a chance to cure, correct it, and go forward. So that's all well and good. That was there. That was process that we've been using for a long, long time, and it had been working. But as we know, nowadays there are updates to these title reports that would come out, and everybody kind of operated under the idea that okay, if there was an update to title, you could go back to the language that was in the contract and say buyer had a chance to review these. You updated it and you changed it, so therefore buyer should have another opportunity to review it and ask you to fix it if there was a problem. It was the intent of the contract. It was in there. Buyer always had the ability to do that, but we wanted to make it crystal clear in our forms that buyer had that additional chance to look at it. And so if the preliminary title was updated, or I guess they call it revised disclosure, then what we've added in here was this section. This is second paragraph in here that says after receipt of the initial preliminary title commitment, right? So this says if something should come up and there's a review, then there's another chance for the buyer to review it and to object to it. And again, it's only fair, right? If there's going to be something updated to title, buyer needs to be made aware of it. Buyer needs to have a chance to object to it. Now let me pause here for a second. There's been a lot of comments about, oh my gosh, this is like giving buyer a second way to get out of this. And while the first one is a bit wide when it comes to looking at title, and the buyer wants to object to title, the second one is actually very narrow. And what happens is, for example, we've heard a situation where maybe just what they call a date down, and I don't profess to know all the title company buzzwords that they use or things like that, but for example, if a title report or disclosure was merely updated with a date, is that a revised disclosure? Of course it is. But is it, so does buyer now get a chance? Yeah, buyer does, because something changed. But it's very important that you look at on the screen here. I'll highlight it. And it begins right here on the end of 149 and 150. The objection must be based on a specific condition stated in the revised disclosure that was not previously disclosed. So a lot of you can be looking at this and this might be ringing a bell with you, and you think, I know where this came from. You're probably right. Came from the RE25. When there is a property disclosure at the beginning of a transaction and the seller makes certain disclosures and then discovers something, and there has to be an updated disclosure, whether maybe there's water intrusion, maybe mold was discovered, maybe there was a tornado that came through that buggered up the roof, and so now you have to make those disclosures to the buyer. Just like in an RE25 circumstance like that, when a seller updates it and says, hey, by the way, now the roof is trashed, the buyer gets to look at it again. Buyer can object and terminate based upon that new disclosure. But again, it's very narrow in the 25, just on that new, buggered up roof. That's the only thing they can object to. They can't go back and say, oh, well, actually, it turns out, there was something else you disclosed I didn't like. That's not going to fly. So that all got carried into this. It's the same circumstance. So it's a very narrow circumstance for when it's updated. The buyer must object on what was updated. On a date down, the only thing that was updated was a date. There's no objection for a buyer there because it's not going to have any material effect on the title. So that gives buyers, this kind of codifies what was always going on out there, but it gives buyers a very clear right to look at these things should they be updated. So that's part one on the buyer side of things. Let's move into part two. This was the second thing that was added to this change, and it's down here 161. It's this last paragraph, the fourth part of this section, if you will. And this is something that was to provide a seller a remedy. And the Forms Committee spent a lot of time talking about this circumstance, and there was a lot of comment in the committee about sellers who were getting caught and placed in a very, very bad situation where there was something that comes up on title that they were unaware of. And for example, we all know that when a seller selling their house, what they're talking to their list agent, one of the conversations they're having is, look, this is what I need to put in my pocket. This is what I need to net on this transaction after I pay off the mortgage or pay off the liens or whatever. This is what I have to net. And by the way, that could be a domino effect because they're going to buy another house with it and kind of go forward. They go out on the market, they list their property, there's a preliminary title commitment pulled, and lo and behold, something shows up on that title that says, wait a minute, here's this lien. And that's going to reduce what seller's going to net, because as we know, the liens are all going to get paid off at closing. And so now seller says, oh my gosh, that's seriously affecting what I thought I was going to get. In fact, now I can't even go out and buy a new home, and I'm going to be homeless. I'm going to be forced to sell my home to this buyer, it's a serious situation for sellers. It's a problem, and so the purchase sale agreement did not allow the seller an escape because of that. It allowed buyers to review title commitments, but it did not allow a seller. And so there's a lot of comments here. I'll get into them in a minute on questions about this, but the committee at the end of the day felt that this was a serious enough situation for seller that the seller should be able to get aware of that. But they realized the abuse that could happen because of this, and so they talked through some examples and said, well, how do we do this? How do we neck it down? How do we keep it so that the sellers are not abusing this section? And that's where the specific language came in, and it gets very, very important. So let's take a look at it. Right off the bat, this has to be something that seller was unaware of. So this is not a situation to where, seller hoped that they were sliding something by the goalie, getting something by the goalie where, this lien wasn't going to show up. It wasn't recorded against the house. So they were maybe playing a game and I'm going to sell a house. And maybe that's not on there. That's not a circumstance where a seller could utilize this section because they were aware of it. They were just hoping it wasn't going to show up on title. This talks about a condition or defect that was affecting the title of the property that seller was unaware of. So that is first and foremost the biggest way that this gets necked down is seller has to be, I was unaware of this condition or defect. And then the second part is also necks it down, learned of it from the disclosure from the title company, right? So this isn't just, I knew it was out there and I mean, the seller really has to be taken by surprise. Look, I was unaware of this. When I saw the title, I was as surprised as you were that it's on there. This is a huge problem. I can't sell you my property now because, we got to get this taken care of first. And so I have the ability now to terminate this agreement. And that's essential, the part of this. And then, of course, they have to act within 2 days. So this is not something that, a title commitment report comes out and maybe seller sits on it for a while. They get a better offer. Now they're trying to look for a way out of the transaction. Not good seller, but we know what happens, that sellers try to maybe wiggle out of these contracts. So they can't then say, oh yeah, by the way, that's a huge problem on title, so I'm terminating. 2 days is all they get, 2 business days under the default that you can see there on your screen. So again, really necks it down. It's not just an open-ended circumstance for a seller to terminate this. So that's a summary of the two big changes in that particular section. I want to highlight something else that's very important in here, and it's working our way into our contracts. The Forms Committee wants it addressed more and more, and I would expect to continue to see it. This language right here, unless it has become non-refundable. And so in this circumstance, I talked about circumstance part number 1, buyer terminates because of a defective title. Buyer, it says this agreement shall terminate and any earnest money shall be returned to buyer unless it has become non-refundable. The same language exists down here in the seller's transaction. Upon termination, earnest money shall be returned unless it has become non-refundable. The committee has heard a lot about this particular language and saying this isn't fair, that the seller is going to end up terminating and they're going to keep this money for the buyer. That's not fair. Why would they do that? And you can agree with this or you can disagree with this. Ultimately, the forms committee agreed it goes in here and agreed to do it this way. But will it sometimes cause buyers some angst for losing earnest money that went non-refundable? Yes, it will. But buyers need to know when they are making earnest money non-refundable. That's what that means. It is non-refundable unless the seller breaches the contract. If the seller does something wrong, then the non-refundable earnest money is on the table. But that's about the only time it's on the table to talk about. Seller's not breaching if they use this clause in the contract. This clause is a stated out for seller if there's a circumstance they're unaware of. They're not breaching. Now, again, somebody could say, well, sellers should have known about that. And again, that's a valid argument. But ultimately, this was the language the committee landed on. And so it's just really important that you have these conversations with your buyer. When you say non-refundable, that's what it means. And it has to mean that. I mean, there's not, if you get into a circumstance where you say, oh, well, we're going to make earnest money non-refundable to sweeten up this deal or what have you. If you say, unless of course, this happens, or unless of course that happens, or unless of course this happens, pretty soon you don't have non-refundable earnest money. And so non-refundable means what it says. It is non-refundable. And the committee is trying to keep that very, very tight. And there aren't a whole lot of unless, because then, like I said, you're just watering down the purpose of non-refundable earnest money. So that was just that was kind of a background in the conversation that the committee had that led to this language that was inserted into this contract and into these title insurance and review sections. So with that, Nick, I'm going to take a pause here. We're about halfway through the webinar. If there's any questions or comments regarding this section or non-refundable earnest money or...
I have a question. Oh, okay. Pardon me. Would it be inappropriate for a buyer to have the seller waive this right under 153 to 164 and have it non-refundable? The seller says, I want your earnest money non-refundable. The buyer says, oh no. But then the buyer says, well, I'll do it if you waive this title, your right under this title clause. Right. See, in Washington, we get the title report right away. I mean, we have a preliminary. So it's a little different in Idaho,
Mm-hmm.
What was your thought on that?
Yeah, no, that's a great question. And you highlight an excellent point between Washington and Idaho. Between Idaho and Idaho, there are different ways to practice throughout the state. And that's what's unique about your guys' forms. These forms work in a lot of different circumstances, but there are certain circumstances where they don't work. There are ways of practicing in different parts of Idaho that aren't adopted by other parts of our state. And so when you say, would it be inappropriate for a buyer to ask for this to be pulled out? It's never inappropriate for the buyer to ask anything. Except maybe for you guys to work for free, right? You always get that one and say, and actually, again, I'll say it's not inappropriate to ask, but is it going to happen? No, but so a buyer can absolutely always ask to say, okay, you want earnest money, and and the circumstances of every transaction are unique as well. There may be a reason that okay, we want earnest money to go hard here, and we want it non-refundable, and these different things are happening. But if a buyer's concerned about this, absolutely, you can say, look, we don't want this. Don't forget the PSA starts with the buyer in most circumstances, and so you can admit this from the original PSA when it goes down. These are all tools. These forms are all tools for all of you to use throughout the state and throughout the many, many transactions that you do. They can be modified. There is nothing that says, look, statutorily, this is what has to happen. Now, these forms do have the statutory requirements in them, legal descriptions and things like that. And we make sure that they follow the law, but ultimately they can be modified per transaction, per broker, per buyer, per seller. It
seems like a pretty sophisticated seller could take advantage of a buyer with this particular language and a non-refundable earnest money.
If they were sophisticated enough, there could be some funny business going on for sure. But again, they try.
You're sophisticated enough.
Well, there's that's right. Then there's lawyers who get involved in transactions too. We won't go down that lane. But anyway, thanks for the question. That was a good one. And again, that's a good reminder. These are just tools for you guys all to use. If you like them, if you don't like them, your clients and customers can tweak them as they need for each transaction. So, any other comments?
Jason, we had one in the chat from Lisa Holzer. So we need to make sure we don't release non-refundable money until after all title revisions and inspection contingencies have been released.
Well, it depends on when you make the earnest money non-refundable, when it goes to seller, things of that nature. Ultimately, there is, if you go into our breach section, the default remedies on default, there's a remedy in there that says that if a seller breaches, then the non-refundable earnest money could come back. If you've already released it, it can make it harder to get back, yes, but legally, the law doesn't care who's got the money. The law is just going to look at what's right, what's wrong, who's entitled to that money. So, but I know that, and we always say it's best practice that when you do non-refundable earnest money, or talk about non-refundable, talk about when it is going to be given to the seller. And so if you want to hold on to that longer now because you think, okay, this is maybe something that's out there, we got to watch it. Nothing wrong with that, but just say it's always best practice to say when it should actually be given to the seller, because you can say, oh, well, my non-refundable earnest money is still a title company until closing, or is it the seller actually gets to go in there and take it out, put it in their pocket, and walk away with it. So not that you can't take it back out of their pocket if they do something wrong. The law will do that, but good comment. Anything else?
That's it for right now.
Okay. Okay, so let's move on. A couple of things that we want to touch on in these forms. We'll just, since we're in the purchase sale agreement, we'll stay here. Going to go up to the end of section 3. This is a section where we talk about the buyer obtaining proceeds from a third party. And this line sort of used to live up here, and we used to have just this line that said proceeds from another source, yes or no. The committee felt that was just, it felt like that was just, what are you saying there? It's proceeds from another source. Okay, yes, and then you have to have all these questions. Well, what, when, where? You probably still have to have those questions, but they felt like it made more sense to be down here and live in this particular subsection because it talks about the money that's buyer's going to show up with at closing, and buyer now needs to make this statement: buyer is obtaining proceeds from a third party non-lender source, yes or no. Obviously, if it's a yes, then seller can ask those questions, follow up, say, okay, what where are you getting this cash? Where's it coming from? Are you getting it from your great aunts, or is this like you plan on winning the lottery? And so that you can understand what kind of offer you're getting. What's important about this is it does not have anything to do with a refinance or sell. That line still lives up here. Line 21, right after the purchase price, right away we ask, is this offer contingent upon the sale, refinance, or closing of any other property, yes or no? So now they may dovetail, right? You may click yes in both of those boxes, and going around there and looking at both these lines, is it coming from another place? And if you check yes up here, you're almost always going to be checking yes down here, because again, it's from a third party non-lender source, or from a different a different location like that. But again, with this line 21, we all should know, if you don't, there is another form that dovetails off of this one line. This line says contingent upon the sale. That creates a contingency in this purchase sale agreement, and it allows buyer to get out of this if the sale, refinance, or closing of another property does not happen. This is a contingent, and so a buyer can actually terminate and say, sorry, my other home didn't sell. And so that's a real big yes. When they check the yes box, I would imagine most of you as practitioners start asking a lot of questions, and a lot of those questions are asked on the other form that comes as a result of this. So if you're not aware that that other form's out there, go pull it, go review it, and say, okay, as a seller, when I see one of these from now on, I'm going to make them fill out one of these forms and answer these questions. And it puts some other contingencies and sort of bookends on the sale, refinance, or closing of the property. So just be aware that that is there. Any questions about that topic? All right. Pretty easy day today. This is good. We're not
did you mention there's another form that goes with this if you check yes, if someone checks yes?
Yes, there is. There's another form, and I am not going to be able to pull it up because I don't think I have it right here, and I don't even know what the number is off the top of my head.
Dang.
Somebody else.
Okay.
It's okay. We can.
Does somebody know?
What's the number? That's not. I'm seeing if I have it.
I'm brand new in Idaho. Well,
Okay.
35 years managing broker in Washington, brand new in Idaho.
All right.
It's RE 52.
It's what?
RE 52.
And
Bless you.
actually,
Thank you.
I do have it, actually. I have access to it. So it's right here. Can you see it on the screen, the RE52?
Yeah, we can see it.
Great. So this is the property sale contingency addendum. And again, I apologize for forgetting the number. It's something that was just added a couple years back. But this, as you can see, this particular form is very valuable to if you're going to make it, contingent. That's what this form was designed for. And so it asks the questions that you would normally be asking. Buyer's property. What are we talking about buyer's property? Where is it? The city, the state. What's the listing status of it? Is it listed for sale? Or no, not yet, but we're going to, as soon as you accept our offer, we're going to list it. Who's the brokerage? What's their contact information? That type of thing. And it gives permission for the list agent on this other transaction to talk to that one. Where are we at? And contract status. This whole thing here is where are they? Excuse me, in the contract. And by the way, if any of this changes, then it can terminate the agreement. And again, buyer gets their earnest money back unless previously non-refundable. So that was changed this year. So you can see that on your screen. But you have contract price, closing dates, all these pending contingencies. And then there's down here, there is the number 5, which is the big part of this, that there's a notification to the seller in the change of circumstances. So if I'm the buyer and I'm selling my house in Mississippi to buy a house in Idaho, and something happens with the house in Mississippi, I have to let the seller up here know that literally within one business day of any big circumstances that may change. And then there's, of course, the termination clause and removal, and then opportunity for other terms and conditions. So it's a great question, and good for us to all just be reminded about these practices. And
What happens if he doesn't tell him within a day? Is there some kind of consequence?
Well, yeah, they're in breach of contract, and so anytime you're in
Okay.
breach of
All
contract,
right.
yep, there are consequences. Yep, good questions.
Jason,
Okay.
we had
Yeah.
a question about the last form you're looking at before the RE52 about the logic of not naming the seller on page 1. Do you want to speak to that really quick?
Sure. There's always, so what they're talking about is on our purchase sale agreement, which I will try to find, but hold on, my toolbar is blocking what I need to get hold of. My 21, where is it? Okay. So we're looking here at the RE21. And what you can see is you've got listing brokerage and selling brokerage right at the top. You've got the buyer. There is no place for a seller's name to appear on the purchase sale agreement. And this is a discussion that comes up a lot. And the Forms Committee spends a lot of time talking about it. But so far, it has not changed. And ultimately, what happens is the seller's name ends up down here in our signature blocks. This will be where we see seller signature, right down in here. And you have seller print name. And it lives down there, and there are lots of arguments for doing it at the top. There's lots of arguments for doing it at the bottom, and it's just honestly not a legal. I can't give you a legal reason for doing it one way or the other. Obviously, the parties all have to be named to have a valid binding contract. You have to know who you're contracting with, and you have to, the person you're contracting with has to sign it. So, from a legal standpoint, seller's name has to be in there. Seller has to sign it. But where it is legally, the law is not going to care. But from a practice point, there are some people who really like it down here, and I know that there are people who are very passionate about not moving it off of this to put it at the top. So you'd have to take that up with a member of the Forms Committee. There's not a real good black and white reason for that. But it does dovetail us into the next thing I was going to highlight on is here you see the responsible broker shall be, that's highlighted. That's not a change, it's just a relocation. And it used to live a little bit further down in our purchase sale agreements, but because the responsible broker is such an important part of the transaction, we wanted to make sure that we list it right there at the top, right after we talk about who the listing brokerage is, who the selling brokerage is, and the responsible broker, because the responsible broker, as we all know, has certain statutory obligations beyond holding earnest money that there's things that they have to do that they have to be aware of. And so I wanted to make sure that is a critically important statement right there at the beginning of our purchase sale agreements. So you'll see that's been relocated on all of our purchase sale agreements. But again, just a relocation, not a change. It's a great question. Anything else, Nick, or do we want to move on?
That's it for right now.
Okay. Well, now we're getting into just kind of some of the formatting changes. This one that we're going to do here is, I'm going to make sure I pop up. Sorry, toolbar is in the way again. Okay, so on the RE25, we actually had a couple questions about this. Why was this changed, and why are you adding this? The This is literally just a format change. So this has always lived here. It has always lived in the document. And this is, so if you look at the RE25 and, we're getting down here, this is what it looks like down below. That's where we have all these disclosures that can be made regarding our forms. This we used to be just sort of radio, or they were like a check box at the top. And the committee wanted to change it just to make it look like the rest. But it's great because every time we make a change, it's great. People are paying attention and they want to say, "Oh, why did you change that?" It literally wasn't a change. It's just formatting. But the point of it is these are things that have to be disclosed about a property, no matter what. It's a lot of times you're exempt from filling out a property disclosure form, but you still must answer 1, 2, and 3 on this form. And so if you fall under one of the exemptions, there's actually a different RE25 that you can use, but you'll note these are still there because a seller always has to make these disclosures. And as you can see, they relate to the area of impact, falling within city limits, or annexation. So that, again, very important things for a buyer to know about property. Want to make sure it's disclosed right there at the very top of the form to have it filled out. But again, that was just formatting. So hopefully not a ton of questions about that, but I'll pause in case there are. We're going to move on to the RE16.
We just got a question. If property has been a rental, is seller exempt for the RE25?
No, they have to fall within one of the exemptions that would be in the RE25, and you can see a list of those in the other RE25 form has up at the top here. You tick the box as to why you're exempt, but simply because it was a rental property is not an exemption. And by the way, we get this question a lot on the hotline that it might be, don't forget, just because you fall under one of those exemptions and you are exempt from filling out one of these forms, it's not a bad idea to fill one out anyway. And I know that sellers are always pushing back saying, well, I don't want to tell them about this. And, I don't want to tell them about that. And I just want them to buy the property and hopefully they don't figure it out. As a lawyer, and, we constantly say on the hotline when folks are calling to ask questions, disclose, disclose, disclose. Getting into a lawsuit in this day and age, in our economy the way it is, and with the attorney's fees are going through the roof like all the other commodities are right now, and everything is very, very expensive. To get into a lawsuit over a transaction is catastrophic to your clients and to your customers. You do not want them to end up in court. It is going to cost everybody a lot of money, and you as a brokerage are probably going to be drug along just because you were standing in the same room when it happened. You may not have legal responsibilities. That doesn't stop you from getting named in the lawsuit. If I'm representing a brokerage and I'm trying to get them out of a lawsuit that they weren't involved with, it's going to take time, months to get them out of that. And it costs money, it costs time, and meanwhile, the market, if they put a Liz pendants on it, the marketability of the property is very poor. In fact, might not be able to be sold. Just not somewhere you want to go. So have those conversations with your clients about, look, okay, you don't want to tick that box, or you don't want to do this. Like it was an inheritance, it was mom and dad's property, and I want to say, well, I'm a trustee, and so therefore I don't have to fill one of these out. But yet it was mom and dad's property. You were in it 100 times. Mom called you when there was a flood, and there was water intrusion, and that this one bathroom in the back has always had mold issues. And if you know that, disclose that. And nobody ever gets sued for over disclosure. People get sued when they don't disclose. And by the way, they always find out because neighbors talk and neighbors know everything about our properties. And so, it's just not worth it. So even if you don't have to fill out one of these forms, a seller can go through, and there may be a lot of I don't knows. But if you have a chance to disclose something, it's always best to disclose it. And I guess at this point, I should also say, I don't know doesn't mean you can't prove that I know, right? Like if you know, you cannot mark I don't know. You can't say, oh, well, it's like I was saying, yes. If you know there's water intrusion and you say, I don't know, that is fraud. That is a lie in contract. It breach a contract can cause all kinds of problems. So be careful when just doing a whole bunch of I don't knows as well. Anyway, so that was my little side rant on filling out inspection contingencies. Okay, if there's nothing else on RE25, I'll move on to the RE16. We made some changes here. Let me make sure I've got the right ones. Yes, okay, RE16.
Jason, really quick, Chris Coley asked a question about the RE25. comment then question. So the RE25 does not have the three questions. Are you saying they have to complete the RE25A in the top of the 25, excluding else? Example,
Yeah.
transfer of, okay.
Yep. Yes, you do. And again, it's hard as a lawyer to sit on here and ask, answer these shooting from the hip type questions. In fact, I talk to other lawyers when I do these things, and they're just like, you do what? You go on a live video and you give answers to legal questions? Are you crazy? Anyway, so every transaction is specific, right? If you find out where you are in there and if you're exempt from it, but no, those three questions that are at the top of it, you're almost never excluded from answering those questions because it comes from a different place. Okay, let's move on to the RE16. Okay, so if we look at this, no changes to the top of this. Really, the only change that comes, it actually comes out of a paragraph that was added last year, and it's here in the brokerage fee section. And we talk about this is where we talk about what you're getting paid. This is what the seller's filling out. The seller's going to say, "Hey, I'm going to pay you this amount," and this is also where you will talk about cooperation. And I'm going to pay you this amount. I want you to share this with the buyer's agent, or this is what I will agree to pay the buyer's agent, etc. So there was this language that was added in here once we brought in that conversation to our purchase sale agreements, as we did a couple of years ago. In section 20 of our purchase sale agreements, we can talk about where where a seller is willing to pay a buyer's agent or a buyer's broker a certain percentage or a certain amount. And we know that the RE16 comes before the RE21. And so if the RE21 makes a statement that is different than what's in the 16, we want to make sure that they all work together. And so that's where this paragraph that begins on line 55 starts. In the event the seller, subsequent to signing this agreement, executes a purchase sale agreement with a purchaser or any other agreement consenting to pay a cooperating brokerage, the selling brokerage or the buyer's brokerage, an amount different than the amount stated in this agreement, the subsequent agreement shall control, and the total brokerage fee to seller's broker shall be increased or decreased accordingly. So that's what we're talking about, the total brokerage fee up here. This is going to be increased or decreased. And so, again, this is what I just said is in the purchase sale agreement, we change what the seller is willing to pay the buyer's broker. And that's what that did. And we put that in there last year. But as we saw this go out into the wild, which is always kind of fun after the forms committee meets and we make changes, we always comment about like, I wonder what this is going to look like because once they put it out to all of you that use it, a lot of you are going to come back and say, whoa, wait, did you think of this? And did you think of that? So it's always interesting to see, but this was something that came up that they thought needed a little refine. It would be for that transaction only, which is kind of obvious because a purchase sale is specific to a transaction with a specific buyer. But nevertheless, the forms committee wanted to make this clear that it is for that transaction only. So, for example, there's a brokerage fee up here that's a certain amount. A buyer makes an offer that is really great to the seller, and the seller says, "Yeah, I've got some more room now to compensate your agent. Let's jack that up a little bit and pay your agent a little bit more because that's what you have to pay your agent." I get it. All these things that come into that play, but you're just doing it for that one transaction because that was an above ask price. Now that transaction falls apart. They inspect the home, they find something they don't like about it, so that transaction just goes away. Now what you had to do is go back, well, wait a minute, what did we do? And, is it, did I lower that number? Did I raise that number? Where is it? So by putting this language in here, we just made it very, very clear that it was for that particular transaction. This also is reflected in RE16A, which you will see here. This is our broker addendum. And so this was a place where there was, this is another place where you could change a compensation amount. And this total brokerage fee always lived in here. But again, the forms committee felt like we needed to have a little better options here. Is it going to change for all transactions or just for that transaction? So maybe it's not addressed in the purchase sale agreement, but for that transaction, they're going to offer a different amount. You could tick that box and say only for the transaction involving John Doe. Right. Or only for transactions where I get a full ask price or, whatever. You can fill in that blank however you want to. But these two things were added. They are 16A. Again, tools for you guys to use, for your clients and customers to use. You can decide you don't want to do that. It's for all transactions. You just want to leave it that way. Fine. Tick that box. or if there's something specific, you can do, the other terms and conditions on this particular form. But those are the changes that were put in place to allow flexibility. And if a buyer's agent's compensation is going up and down, we know we're going to tie it to a specific transaction now. So with that, that's the rep agreements, all I had for that particular part of it. And we've covered a lot of it in these, but I'll pause here. Any questions on the RE16 or the 16A changes?
Question we just got from Alan Cofield. Do you have to include anything about paying a cooperating broker at contract with seller and just let the seller make a decision on case by case? Just solidifying your commission with the seller, question mark?
Okay, so good question, and this leads us right back in the conversations we've been having a lot in a post-settlement world. That what does this look like? And you guys know, because you're getting the conversations. It's fascinating that the lawsuit that was settled, that had practice changes in it. It was fascinating to watch how buyers perceive that. It sounds funny, but I'm telling you, it happens, and you guys probably know this. But a buyer had one we had called the other day, and it was a buyer saying, "No, the lawsuit said that I'm not paying you anymore. That you have to work for me, and I don't have to pay you." It was it's just, I mean, they honestly believe that, and it's it just makes you scratch your head, and you say, well, in what world do we have forced slavery? We got rid of that a while ago. So that obviously that's not what it means, but there are all these different ways for compensation to work, and we know that sellers and buyers are in charge of that compensation, but the market also controls. And so I've had brokers have conversations with their sellers and say, look, as a seller may come out and say, oh, I know what the lawsuit said, and I read the lawsuit, and the lawsuit says I don't have to pay you to sell my home. Also not accurate. You do have to pay somebody to sell your home, but do they have to pay a buyer? No. Or a buyer's agent? No, they never ever did. They never had to offer or do cooperation after some changes, but going back several years, that's something that was always subject to negotiation. But if a buyer has a contract in Idaho with their agent and they're hiring you to say, hey, I need you to go find some homes for me, and here's what I'm going to pay you, the certain percentage or a certain flat rate or however you want to structure it, and then that buyer wants to get that from a seller's agent, they're perfectly within their rights to say and to ask that and say, look, I'm going to make an offer on your home, and I have to pay my guy X percent, and I want you to pay that X percent. And the seller can say, yeah, it's not a problem. We already talked about it with my agent. I understand how that works, and it's baked in. Or a seller has said, well, I want to look at this on a case by case basis. Are you giving me, is this a full price ask? Because if it is, maybe I've got some room to work here. And so there's many different ways to structure that, and as there always has been. And that's why it now lives in the purchase sale agreement, so that it can be negotiated. And by the way, a buyer is, we've had conversations where somebody says, oh, my seller's not willing to pay anything to a buyer's rep, and that's seller's prerogative if they want to do that. But if I'm looking for a home for my client, I say, hey, client, look, you got to pay me X percent. You and I have a contract. Do you want me to show you homes where there isn't something being shared? And that buyer can say, well, no, I don't want you to, because I can't possibly afford that home and then reach in my pocket and pay you. I need this baked into financing or whatever happens. And so again, a buyer's perfectly within their rights to direct their agents that same circumstance. And it doesn't mean that if you're showing somebody a home and the seller's saying, look, I'm not paying anything for buyer, they're within their rights to do that. And buyer can say, yeah, I want to buy that home. You just got to remind the buyer, say, that's fine, but remember, you have a contract with me. You're going to pay me for my work that I did to do this, just like everybody. And so that needs to be part of the conversation. And ultimately, a buyer may say, oh, well, I can't afford all of this. Well, then they can't afford that home. And there's nothing illegal or inappropriate about that. You've entered into a contract beforehand. That they don't get the consumers of America don't get to come back and say, well, I really, really want that home, but I can't afford that home and to pay you at the same time. And so therefore you have to work for free. That is not what the lawsuit was about in any way, shape, or form. So anyway, there's a lot out there still in regards to that. So it's always good to have those conversations, and hopefully I answered the question. It took me forever because that's what lawyers do, right? We answer questions based on what we get paid hourly. All right, Nick, that covers, I don't, we kind of dove into the big changes, the forums, as always. Watch all the forums for all the changes, watch the videos. There's a lot of different ways to learn and educate yourself on what's different about these forums. And we always encourage everybody to spend a lot of time with this. And it's important to know when changes come out and know what all those changes are because they can affect everybody's legal rights in the transaction. So, Nick, that's what we had down to cover.
And Jason, we have a couple of questions left, if that's okay.
They're okay until somebody asks a hard one, then I say I have to go.
What's the best practice for receiving fees from seller or seller's agent and from the buyer who has signed a buyer rep with an agreed fee?
What's the best way to receive those? If we're talking about just like logistically, you do it at closing, it gets taken care of on the sheet. But what's the best way to for a buyer to convince a seller to participate in cooperation? It's just the conversation of explaining how this works, and it works on both sides. It's education to both parties, whether you're a listing agent or whether you're a buyer's agent. Everybody needs to understand you guys do not work for free. You shouldn't be expected to work for free. We know that there are sellers who say, look, I'm just absolutely not going to do this anymore. I think this is, they've read whatever horrible news story was out there and they say, I'm not going to do this anymore. I think it's a conversation to be had with them and say, that's fine. Look, I work for you. You're going to pay me my percentage. Okay, that's great. But keep in mind, there's somebody on the other side of this that is doing the same thing. And you just need to explain to the sellers how that works ahead of time. And hopefully list agents are doing that. And again, it's not a bully tactic or a antitrust thing where you're saying, look, unless you do this, we have to do that. It's just common sense. I mean, the buyers are smart out there. The buyers are educated. They know that they need realtors to represent them in this transaction that is one of the largest transactions in their lives financially, and they want to have somebody in their court, by their side. And so, for a seller to come back and say, "No, you don't need representation," it's like sitting across the table from a lawyer. When a lawyer tells you you don't need a lawyer, you need two lawyers. So you need somebody looking out for you in your court as a buyer. And so when you go to a seller and you say that and say, look, I've got somebody, you've got somebody working for you, I've got somebody working for me. And I wouldn't expect you to get rid of your representation. You shouldn't expect me to get rid of mine. I've got a contract with them where I'm going to compensate them. And this is what this looks like. So let's, if we need to adjust offers or what have you, let's have that conversation.
Yeah. We have one last question, Jason.
Okay.
Question about the RE21, line 67. They're saying they don't see how the financing addendum can be dated the same date and attached to RE21 when the seller has to complete the financing addendum.
RE21.
Line 67.
Line 67. Additional financial terms are contained in a financing addendum of same date attached here to and signed by both parties. So the financing addendum is another form that lives within our library, and it deals obviously with different financing things, but I don't know what, I guess I don't understand the question. Because that form might live, or because let me answer it this way. I guess I do understand the question. If that's not there at the time, then you don't tick the box. But you can always drop into other terms and conditions and say that this will be contingent on a form that we're working out or a contract that we're working out that you can mention it in there, or you don't have to mention it. But once you do get it worked out, you can bring it back in as an addendum to the transaction. Just use one of our addendum sheets and then incorporate the new agreement into that. But you're right, you would not want to check that box if it's something that's not existent at the time of making the offer. Maybe that's what the question is people have to continue to have conversations, and you can also just send over the offer and say, hey, by the way, we've got these additional financial terms that we need to discuss, and here's what we'd like to do. And then you go back and forth, and eventually maybe you can get it done by the time everybody signs through counter offers and addendums. But keep in mind, if something's not an addendum to a contract, it's not a contingency of it. It can't affect the contract.
Perfect. Okay.
Yeah.
Jason, I think that is it. We're about at time. So everybody, thank you so much for joining us today. Jason, any final thoughts?
No, thanks everybody for joining in, and hopefully we gave you something to that you leave a little better than you came in, and that's what we're always shooting for. So hopefully we answered your questions. And as always, there's the realtors are there for you 24/7. They're all over the place all the time. Go to their website. They're doing lots of great webinars, and they're always there to help you with your practice. So keep tuning in to this great stuff the realtors do for you guys.